The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain buy-sell agreements for closely held corporations, LLCs, and partnerships. So first, what is a buy-sell agreement? It's a contract between the owners of a business, usually a small ownership group, that sets forth certain triggering events that will require or allow the company to purchase an exiting owner's shares. So these events might be the death or the disability of an owner, the voluntary sale of an owner's stock, the involuntary removal of an owner from the company, either for good cause or otherwise, the bankruptcy or divorce of an owner, the retirement of an owner, or the termination of an owner's employment with the company. And the bottom line in these agreements is you want to provide financial security for all of the owners at the outset of the company so that all of the owners, regardless of what happens to whom, have some certainty as to who they're going to be doing business with. And on the flip side of that, if one of the owners have one of these triggering events, it allows the owners to have some certainty as to what their stock will be sold for, how they will exit from the company if they're forced to do so. These agreements will provide not only for what the triggering events are, but for each triggering event, it's kind of a different flavor of who will be permitted or required to buy their shares, how the shares will be valued for the purchase, and how the purchase will be funded. So when we talk about share valuation, it might provide that the shares are going to be bought at a particular fixed price or fair market value, which may require an appraisal, or there might be an industry-specific formula for how the shares will be valued. When we talk about how the purchase will be funded, if the company is going to be required to buy the shares of an owner, we don't want the company to have to make an emergency capital call when they're not expecting to do so. So sometimes this will allow for like life insurance on the owners if it's death or disability of an owner. So the life insurance will fund the purchase in the event of death or disability. Or it might be, depending on the company's financial situation, it might provide that a account is kept liquid for such situations, or a loan will be acquired, or it might be financed to the seller. So the company will have a promissory note where they pay the purchase price over time. So not only do you want to make sure that you know what events are going to trigger a purchase of an owner's shares by the company, but also how is that how are those shares going to be valued? How is the purchase going to be structured, and where is the money for the purchase going to come from? This agreement might be included in the governing documents of the company, like the operating agreement, bylaws, or partnership agreement, or it might be a separate document. Either way, you want to make sure you negotiate your buy-sell agreement as soon as possible in the life cycle of the company, because the longer the company is doing business, the more likely it is that the interests of the ownership group are going to diverge from one another, and it will be harder to negotiate the exit of one party from the company. So, for example, as the company is going on, one owner might want to make it easier for him or her to exit the company, while other owners may want to make it harder to exit and restrict the sale of stock to third parties. And usually that's something that's very easy to negotiate before those positions are reached, but very hard to negotiate once one owner knows that he or she is going to want out of the company. So you want to do it as soon as you can. Usually when you're negotiating all of the other parts of the operating agreement, you can include a buy-sell agreement right in the operating agreement of an LLC or the bylaws of a corporation. So let's talk about some of the specific scenarios where you might want to use a buy-sell agreement. One is the death of an owner. So you don't want to, if you're an owner of a company, necessarily be doing business with a deceased owner's wife, husband, or children, or whoever their heirs might be. In the absence of a buy-sell agreement, the deceased owner's estate is going to basically get control of the shares, and whoever inherits the shares will have all the rights that the deceased owner had in the company. Well, those people probably don't want to be learning how to run a business either, and they might prefer a lump sum payout. So a good buy-sell agreement might provide that the company will buy insurance on the lives of all of the owners, and if one of the owners dies, the insurance company will pay the company, and the company will be required to buy the deceased owner's shares from the deceased owner's estate at fair market value using the proceeds from the life insurance. So the other remaining owners don't have to do an emergency capital call. They get the capital from the life insurance, and the estate gets a lump sum payout for the value of the shares at a price that's set in the operating agreement or a formula or fair market value. and they don't have to learn how to operate a business or be in business with people they've never really had a relationship with, and neither do the existing owners. So everybody ends up being happy. In a situation where you want to limit the sale of an owner's stock, this might be there's 3 owners, they're friends, they don't want to be doing business with someone they've never met before and who doesn't share their values. So in the agreement you provide for, if one party wants to sell their stock and get out of the company, how is that going to work? And often the most fair way to do this is a right of first refusal, but this provides complications where you have an emergency capital call in order to pay for the stock. Another way to do it is requiring the approval of the owners, and the problem with this is that you can have one owner held hostage by the other owners and being forced to sell their stock at a lower price to the remaining owners. So a way to temper that is to have an approval requirement combined with a mandatory purchase requirement. So if the owners don't approve of the sale to a third party, they have to buy it, but it might be at a reduced price because they're not anticipating they don't want to incentivize owners to leave. So the owners might have the option to purchase, or the requirement of purchasing it at a reduced price from market value. This is probably one of the more complicated scenarios because you want to balance providing certainty as to who you're going to be doing business with and preventing an owner from selling their stock to someone that you don't like against holding an owner captive and forcing them to sell at a severely reduced price. So it becomes really important to know what the price is going to be that they have to sell to the other owners at the outset, so that it's not a negotiating tactic to say we won't approve the sale unless you sell it to us at this very, very, very low price. So we're going to have another article and video on restrictions of transfers of stock if you want more detail on that. And really each of these scenarios we talk about, we're going to have an article and video on at learn-about-law.com. Finally, we'll talk about retirement of an owner. So the agreement might provide that if an owner provides a certain number of years of service to the company as an employee, they are allowed to retire after giving a certain amount of notice, and the company will buy them out. And it might provide that it does so over time through essentially a pension. It's a payment from the company of a certain amount per month as they purchase the owner's shares over time. Or they purchase the shares all at once, but there's a promissory note that gathers interest. But it provides for some certainty as to what happens as owners decide to retire and when they're allowed to retire. And it provides someone who doesn't usually have a lot of certainty about retirement, the owner of a small business, with some certainty that they'll be able to be paid for their stock all at once or over time. So like I said, we're going to have a lot of articles and videos about buy-sell agreements, how to fund them, how to structure them at learn-about-law.com. So if you want more details about any of the aspects of a buy-sell agreement, go there and check that out. This is really the general 101 article that gives the broad view of buy-sell agreements and how they work. If you have any questions, you can leave them in the comment section below this post or below the YouTube video on our YouTube site. The post is at learn-about-law.com. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several offices located all over the place geographically for your convenience. If you found this helpful, we'd love it if you subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you consume your video or audio. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.